criminal cases in which individuals were recently arrested and booked at the Fulton County Jail. Upon being processed through intake, the Fulton County Prosecutor, which is the Solicitor General's office, has already formally accused the cases, and hence this would be the defendant's first appearance with a state court judicial officer. During the course of this civil proceeding, which we are handling through a virtual format, which is also recorded and live streamed, please take note of your rights, and this is specifically for the defendants. You have a right to remain silent during the course of these proceedings, which is recorded. Your statements can and will be used against you in the treatment of your case. So please do not say anything unless you have the advice of counsel. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. When I call your case, I'll let you know what's the accusation number brought against you. What are the charges that are going to be, what are the charges of which you've been formally accused? Who's going to be your attorney? What is going to be your bond if one has not been previously set? As well as to give you a court date.
Next, opposition number 13, Mr. Bishop Rowland.
Okay. Ms. Grant, I will address your question shortly. Let's address Bishop Rowland, 23 CR 0031731. Mr. Rowland's accused of battery, domestic violence from an April 10, 2023 incident. Ms. Rowland, you've been advised of your right to remain silent, and your attorney is Ms. Wills. Any priors, Mr. Howard?
What the rest? Last arrest was back in October. Suspended license. On probation for that. 2018 simple battery conviction. 2014 suspended license for this one.
Thank you. Mr. Jones?
Yes, Your Honor. So the state's recommendation is going to be a $3,500 surety bond, stay away from 2649 High Tower Court, Northwest Atlanta, Georgia, and no further contact with Ms. Crystal Rowland. The reason for this is the state is concerned for the intimidation of witness. This was the defendant's girlfriend, and she was assaulted by her child's father. The defendant got upset after the victim asked for a house key, and then he proceeded by throwing a bottle at the victim's head, slapping her across the face, and pushing her to the ground, resulting in cuts. Your Honor, we do not believe that there has been a fair cooling off period. Also, the defendant fled the scene with his mother, so we are concerned with his ties to the community, as the mother did take him away from the house. Also, the danger to the community, as you heard, the defendant has a previous simple battery conviction in 2018 with another young lady, Your Honor. So for those reasons, that's why the state is asking for the $3,500 surety bond, stay away from the incident location, and no further contact. Thank you.
I see a Crystal Rowland on the Zoom. Would you like to be heard?
Yes, Judge.
All right, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. Yes. What would you like to tell us?
That I'm okay with him returning to 2649 High Tower Court, and that I do not feel fear for my life, or I'm not in danger.
And why is that?
Because the argument just got a little bit heated, and it just escalated, and I had part in that.
And Mr. Howard, do you know anything about this Douglas Bill hold? He's got a probation violation. Is that for the?
That's probably traffic. But if it's probation, it's probably for traffic.
Traffic. Is that the suspended license?
Correct.
Okay. All right.
I have to look it up.
Ms. Wills?
Thank you, Your Honor. My client is 30 years old. He has resided in the state of Georgia for the past 14 to 15 years. Him with a knife and then threw a knife at my client. Mr. Rowland states that he defended himself, and that Ms. Rowland also tried to pull his hair out during the altercation. My client states that his mother was present when all this occurred, that she witnessed everything, and that he left not to flee, but to cool off after the situation had escalated to that point. My client reports that he did not know he had a warrant for a significant amount of time. Again, this happened on April 10th of this year. My client reports that his father recently passed away, and he passed away shortly after this incident, which is what caused him to violate his probation. He was actually out of town and missed his court date because he was gone for his father's funeral. I would ask for a signature on bond, Your Honor, as my client does not have a job currently. He states that nothing like this has ever happened between himself and Ms. Rowland. And if Your Honor is not so inclined, I would ask for a $750 surety bond and ask for no further violent contact between my client and Ms. Rowland per her request.
So, I'm just trying to reconcile this with what Crystal Rowland just said. So based on what Ms. Rowland said, she said it was just a tussle. But now there are allegations that she allegedly stabbed him with a knife, which is a aggravated assault or aggravated battery felony charge against her, if that's the case, and that she pulled his hair, which would then be a simple battery charge against Miss Rowland, if that's the case. And if that's the situation, then I guess, Miss Rowland, do you have any comment about that? Because this is all on Zoom being recorded, and the prosecutor's hearing all this. So you're telling me now that you're comfortable with him coming back to you and you possibly facing felony charges?
I am comfortable with him coming back, and I did not.
Miss Rowland, let me go a step back.
Okay.
They are saying in the presence of this Zoom recording, with his mother being present, that you allegedly stabbed him with a knife and pulled his hair.
Well,
And so are you telling me under oath that that's what happened?
I did not stab him. No,
Did you pull his hair?
I did, but that was during the altercation.
Did you instigate pulling his hair?
It was after I was
Let him back into the same home with you. Thank you, Miss Rowland. You may mute your screen. On the battery domestic violence, it's going to be a $5,000 surety bond. No further contact with Crystal Rowland to stay away from 2649 High Tower Court. And upon release, he's not allowed to return to 2649 High Tower Court, and he's not allowed a one-time visit. If there are any belongings that reside at that location, Miss Crystal Rowland can go ahead and make sure that those items are available for his pickup through a third party. If they share any children, I will allow for third-party transfer of the children. No illegal drugs, no alcohol, and no weapons. Thank you. Next court date is June 1st. Ms. Crystal Rowland, I highly recommend that you speak to the Victim Advocate's office at the Solicitor General's office to go over this case and make sure that you don't subject yourself to being charged with any crimes. Thank you. Yes, I am.
Okay, this is position number 11, Ms. Rhonda Oliver.
Okay. Rhonda Oliver is accused of battery domestic violence from May 18, 2023, accusation number 23CR003174J. Ms. Oliver, you've been advised of your right to remain silent, and your attorney is going to be Ms. McLeod. Any priors, please?
First one.
All right. Mr. Jones, what's the recommendation?
Yes, Your Honor. The state's recommendation is going to be a $3,000 surety bond, a stay away from 979 Woodburn Drive, Southwest Atlanta, Georgia, and no further contact with Mary Tolbert. The reason for this recommendation is A, for the intimidation of a witness. Ms. Mary Tolbert, which is the victim, is the mother of the defendant, was struck in the face with a closed fist several times, causing physical harm, visible swelling to her right eye. We do not believe that there has been a fair enough cooling off period. Therefore, that is the reason why. And also, the victim has stated that she does not want the defendant to return home, nor does she want to have contact at the appropriate time if Your Honor can stand for the victim if she's on. Thank you.
All right. Mary Tolbert, if you're present, please unmute and start your video. All right, Ms. McLeod?
Hello.
Answer. There she is. There's someone called Andre.
Yeah, that's my daughter. I'm on her.
Okay, you need both to sit facing the window, the other way around. The window cannot be behind you because all I see is your silhouette. It's just a little photography thing I've learned from, very bad photographs.
Okay.
All right, now you can be seated.
Come on, keep it.
All right, who is Mary Tolbert?
I am.
All right, and Ms. Tolbert, if you please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right, Ms. Tolbert, what would you like to tell me?
I don't want her in jail, and I know she don't have no money. She's my grandbaby mama, and I want her with the baby. And she just recently started her job at the local hospital, and I want her to be able to go to work. The only thing I want her to do is move, because she's not serving no financial help here or anything. I didn't even want her to go to jail, even though I didn't want her to be arrested. I know about this stuff, but that's my grandbaby, and that's my grandbaby mama, and I want her at home with him.
Where's the child? Where's the child?
He's here with his dad now.
And does she have a place to go once she retrieves her child?
I don't know.
Okay, that's all I need to know. That's all I need to know. Thank you. You may mute your screen. Thank you, Ms. Tolbert. Ms. McLeod?
Yes, Your Honor. My client is 26 years old. As has been noted, she has no arrest record at all. She is gainfully employed as a CNA, she tells me. Mm-hmm. She is also the mother of an 8-month-old child. The complaining witness is the grandmother of the child. The father is the complaining witness's son, and they all live in the household. My client
So I'm sorry. So the biological father lives with the child as well in grandma's house.
The biological father is the complaining witness's son.
I see. Okay.
And my client.
I will address you, Miss Oliver. You put your hand down. Yes, go ahead, Miss McLeod.
So, Your Honor, she's never been arrested. We would ask for a signature bond so she can get out of jail. She doesn't really have anywhere else to go at this time, but I understand that the complaining witness does not wish to have her there. So we, of course, are going to be guided by what the court orders. She tells me that she does have some things for her baby, and of course her baby's there, so she's going to need to go back to get her baby.
All right.
Definitely has a signature bond so she can get out of jail and get on with her life and no further violent contact with the complaining witness, who is the mother of the child.
Unmute courtroom 2, please.
Good afternoon, Judge. How are
Good
you?
afternoon, Ms. Oliver. I've said it, I'm sure your attorney has said it. If you want to discuss your case or circumstances of your case in open court, anything you say can and will be used against you. If you waive your right to remain silent, you open the risk of being incriminated and making it very difficult for your attorney to represent you.
Ms. Oliver, unless this concerns your bond, I would advise you not to speak.
Okay.
Do you have anything to say at this time, Ms. Oliver?
I'll just take the advice of my attorney.
Okay. Miss, the bond is going to be set. It's going to be a $5,000 signature bond through pretrial services. No further contact with Mary Tolbert, and to stay away from 979 Woodburn Drive in Atlanta, Georgia. She may return one time only with a police officer to retrieve her belongings and her child. If the Miss Oliver, and I'm sure your attorney has explained this to you, if you have your child outside of wedlock and the father has not filed a formal legitimation action in superior court, then the only person who has full custody of the child is you. So you have the absolute right to remove your child when you go there for your one-time visit and pick up your belongings and your child. Do you understand?
Yes, Judge. May I just intercept the question, please? I understand that I was advised not to, but just for future references, how is it supposed to go about my son having his relationship with his father?
Well, let me move on then.
Okay.
As I was saying, no further contact with Mary Tolbert, and on your one-time visit, make sure you pick up your child and your belongings because you won't be allowed back there at all. Okay, until further order of the court. You're not to consume any illegal drugs. You're not to consume any alcohol, and not possess any weapons or firearms. You're to report to pretrial once a month. And if you get arrested again, your bond will be canceled and converted to a $5,000 surety bond. That's why it's very important to comply with your conditions. While you are out of bond, also you will attend and complete a one-day anger awareness program with pretrial services. Now, like I said, as long as if the child's born out of wedlock and the only thing the father has done is put his name on a birth certificate, then he has no custody and no visitation rights over the child. You have complete custody and rights over the child. Now, the father can still file a legitimation action with the superior court and get a court order to establish paternity and visitation and joint custody. And if he does that, then he'll be able to begin the process of, like you said, fostering a relationship with the child. Understood? Now, of course, daddy can always come visit you wherever you are living with the child. All right? But you cannot go to daddy as long as daddy's living with his mom. All right. Anything else, Ms. McLeod?
Nothing further, Your Honor. Thank you. And this concludes my business before the court today. May I be excused?
Yes, thank you. Have a great weekend.
Thank you, Judge.
Courtroom 2, you too, ma'am. Thank you. Next case, courtroom 2.
Next, we have position number 15, Ms. Salad.
This is Eros Imani Salah, accused of battery domestic violence on May 16, 2023. Accusation number is 23CR 003171E. Ms. Salah, you have been advised of your right to remain silent, and your attorney is Mr. Judd. Mr. Howard, any priors, please?
Second arrest, 2020, possession of a sawed-off shotgun, sale of marijuana, 2 counts, theft by receiving. That was dismissed.
All the charges?
Yes.
All right. Mr. Jones, what's your recommendation?
Yes, Your Honor. So the state's recommendation is going to be a $3,000 surety bond, a stay away from 2456 Hardwood Drive, East Point, Georgia, and a no further contact with the victim, Mr. Lamar Scott. This is because the intimidation of witness, this was the defendant's boyfriend, and he was battered by the defendant. The defendant got upset after the victim did not want to see her new car. She then pushed him out of the side door, causing him to fall to the ground. The victim has expressed wanting contact and wanting the defendant to return. However, we are concerned about a sufficient cooling off period in the domestic violence cycle, Your Honor.
All right. What did you say, Lamar Scott?
Yes, Your Honor.
All right. And is Mr. Scott on the Zoom? Yes, he was. I believe he was.
Yes, I'm
There
here.
he is. Okay. All right. Mr. Scott, if you'd like to say something, I need to place you under oath.
Okay.
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. I must say, this is one of the better photographs of Fulton County Jail has taken. So I compliment the staff at the Fulton County Jail. But Mr. Scott, what would you like to say?
I would just say I would like to start off just by just basing or talking about the incident. Really, it wasn't over the car. I believe it's because of she's dealing with a lot of stress. She does work 2 jobs. She does take care of her mother. She pays her mother bills. She's honestly been stepping up to the table so much that she has so much on her plate. She's just been so stressed out dealing with a lot, but at the same time, all of her goals, she's been accomplishing them. She's been knocking them out. She works very hard. Like my God just said, she just bought her first car the same day the incident happened. And I really, truly do believe that, it wasn't aimed towards me. It was more, the buildup of stress and getting that release, because she has been through a lot. And, she does feel like, hasn't no one been, it's very hard to take care of people at a very young age. She works 2 jobs, it's very hard. And, that's just basically what I have to say. She's a great person. She's a great friend. She takes care of this household. She has pets. She also takes care of her older siblings. She's the youngest, and she's always taking care of her family. Even when I first met her. So
whose home is it?
I'm sorry?
Whose home is it? 2456.
This is our home.
Our meaning who?
Me and Errol Salad.
So both of you live there?
Yes, we rent.
Who else lives in the home?
No one. We have 3 pets. We have 2 dogs and 1 cat.
Who called the police?
I called the police. I really called them because she already planned on leaving, going to her mom's house to stay and take some break, but it was just more of the attitude, and it didn't seem like it was de-escalating. So I called.
Sorry, but that response just doesn't answer my question. You called the police, right?
Right. Because I wanted them to.
You have the absolute right to call the police. That's not my point. Is asking that question. It's not to question you on your motive. You have the absolute right. So I just want to be sure, under the circumstances, if you are the only 2 occupants, who else would have been there to have called the police? So it was you. Okay,
right.
That's all I need to know. Thank you. All right, Mr. Judd.
Yes. Good afternoon, Your Honor.
Good afternoon.
Your Honor, Ms. Allard, she has lived in Georgia her entire life. Your Honor, she has no prior similars, no violent, sexual, or felonies on her history. I understand there is that 2020 charge that the state brought up. It's my understanding that was dismissed, and according to Ms. Allard, it was expunged. But she may want to check on that if it still came up on a background check.
Expunged? We still do that?
I think so.
I understand.
Yes, Your Honor. Your Honor, the incident was at their place. However, if she is not allowed to go back to the location of 2456, she is able to live with her mother at 2266 Kennedy Court. Your Honor, so she does have an address, a stable address that she's able to go to. She may need to sort out financial issues with Mr. Scott. So if there is a no contact order of some sort, we would ask that it be no further violent contact, or the contact be limited through the phone, if need be, just so that she can work out her finances, Your Honor. We are asking that she be considered for a signature bond today.
All right. Bond is going to be set at $3,000. It's going to be a signature bond in pretrial services.
Thank you.
No further contact with Lamar Scott, with the exception of telephonic communication with regards to finances and arrangements with regards to household matters, since they both apparently rent from that facility. No illegal drugs, no alcohol, and definitely no weapons, no firearms, no sawed-off shotguns, nothing. If she is to stay away from 2456, what was it named? Hardwood Drive? Hardwood Drive? Yeah. And she may return one time only with a police officer to retrieve her personal belongings, including any pets that belong to her. If there's any dispute as to the ownership of any belongings, including the pets, she's to leave them there and resolve the ownership at a much later date, normally through a civil lawsuit. Her next court date will be set to her at her new mailing address. She will be required to update the court with her new address within 30 days of being released. While she's out on a signature bond, she will also need to complete 4 anger management classes at her expense. She may begin those classes within 60 days of being released, and then she'll need to report to pretrial of the completion of the 4 anger management classes. Thank you.
And Your Honor, just for the record, Ms. Allard did not qualify for our office's continued representation, so it was only for the purposes of bond.
All right, who we have next?
Position 1 on add-on calendar. Donegan.
All
All right, Mr. Dunnigan, your case is 23 CR 002977F. You're charged with 1 count of simple battery, family violence, and 1 count of possession of marijuana less than an ounce, each with the offense date of May the 13th. You understand your rights?
Yes, ma'am.
All right, Howard, have these three.
Let's see. Last arrested 2021. Probation violation. Got an open case out of Harris County. 2 counts of burglary. Got an ag assault conviction, hijacking a motor vehicle, possession of a natural firearm during the commission, possession of a pistol or revolver by a person under 18, armed robbery. All those were convictions from 09. Got a 2021 obstruction conviction out of Fayette County. 2021, okay, that's the burglary. That's it.
Okay, Mr. Young.
Yes, Judge. This incident occurred on May 13th, 2023 at 4005 Ronnie Mead Lane in East Point, Georgia, where law enforcement spoke with the victim, Ms. Jessica Sherns, who I see is on the Zoom, so we'd have to court to sound quite inappropriate. But anyway, she told the officers that the accused slammed the door on her leg when she tried to leave. The blade took arm around her neck and pulled her back inside the residence. A witness, the victim's 17-year-old daughter, stated that she heard the disturbance, came and saw the accused with his arm around the neck of her mother, pulling her back inside the residence. Her victim advocates were able to speak with Ms. Sherns, who stated that they had lived together at the incident location. This is not the first incident. She wants to know for the contact and the stay away, and I believe she filed for a TPO today. Also, the victim had later stated that she could not breathe and she lost bladder control when he had his arm around her neck and shaking her from side to side. So at some point, the state is going to see about transferring this up to the district attorney's office. The state does have concerns about the safety of the victim in this case and the risk of reoffense, given the nature of his criminal history and some of his convictions. So with that being said, the state is asking for a $5,500 surety bond. That's $5,000 on the simple battery family violence and $500 for the possession of marijuana. No further contact with the victim. Stay away from the incident location. 1-day anger awareness and one-time police escort and no alcohol, drug, or weapon. I forgot to clarify for the factual basis when officers went into the room to speak with the accused, they noticed a small bag of suspected marijuana on the bed that they believe that the accused was trying to conceal. That's the factual basis for the marijuana case. That's all from the state.
Thank you. Ms. Sherns, I see you on the line. If you would like to make a statement, please raise your right hand and unmute your screen. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, Your Honor.
All right, you can put your hand down. Now, again, I am not sentencing the defendant today, so the facts and your statements about what happened are not as critically important as your position regarding contact or a fear for your safety. That is what the court is most concerned about, and if any facts will illuminate my decision as to that, that is what I would like to hear most. What would you like to tell me, Ms. Sherns?
Yes, I do fear for my safety and for my children's safety. There are always comments of anger and no compromise when we're talking about things. He starts to get out of control, shake, or get explosive. And for my kids are scared, especially my youngest one. I have to get her counseling because she's had problems ever since then. And my family and her dad and everybody is concerned. And so even as a mother, I would ask that he stays away.
I appreciate you coming to court and making that statement. Ms. Wells?
Thank you, Judge. My client is 31 years old. He has been in custody for the past 3 days as he was transferred from another jail. I believe he was arrested in East Point, possibly, and then transferred here to Fulton County. My client is originally from Georgia. He does have a GED. He has 2 children who he has joint custody of, a 15-year-old and a 2-year-old. Mr. Dunnigan is a business owner. He owns Q&N Cleaning, which is a carpet cleaning business, and he has had that business for the past 3 years. He also works for works with Dye Master Group as a subcontractor, and he has been with them for the past 6 weeks. Mr. Dunnigan reports that he allowed the alleged victim to live in his home back in January along with her children. He states on the day of this incident, which was just 3 days ago, it was the alleged victim who was the aggressor, that my client... the alleged victim did attempt to leave or was going to leave, then changed her mind, tried to come back through the door as my client was closing the door. He never intentionally slammed the door on the alleged victim. He alleges that she stumbled through the door. The only time he made physical contact with her was to restrain her from hitting him. My client reports that he even went to his bedroom and locked the door to de-escalate the situation and was trying not to engage. The only vehicle I understand is the only vehicle that was there belonged to the alleged victim, so my client did not have the opportunity or choice to drive away from the residence, and so that is why he went into his bedroom, and according to the police report, that is where he was located when the police arrived. He was in his bedroom. My client reports that the entire incident was caught on his Ring camera, and he did ask for law enforcement to review the video footage. However, they did not. My client's only convictions were, while serious, they are from 14 years ago. I would ask for a signature on bond. It's my understanding that Ms. Sherns has vacated the premises. The lease is only in my client's name. I would ask that he be allowed a one-time police escort to determine that she has officially vacated the premises before he reoccupies it. I would ask that if she is still there and there is a no contact provision, that he be allowed to pick up his belongings with law enforcement as well. And I am asking for a signature bond. And if Your Honor is not so inclined, I would ask for a $750 surety bond. I also would like it to be noted that my client was only charged with simple battery. So given the extent of what the additional facts that Ms. Stearns provided to the victim advocate that were not included in the police report, as far as losing bladder control or consciousness, none of that was mentioned in the police report, Your Honor, and there were no marks or bruises noted. So I would just like to state that for the record.
Okay. At this time, defendant will receive a $5,000 split bond. It'll be $4,000 surety on the simple battery family violence and $1,000 signature through the jail for the marijuana possession. He is to have absolutely no contact with Ms. Stearns or her children at this time. He is to stay away from the incident location should Ms. Stearns reside there. He can return one time with a member of law enforcement to make the determination. If she is still at that location, he must stay away, but he can collect his items. If she is no longer there, he can return. Additionally, he's to have no drugs, alcohol, or weapons as a condition. Is there anything further?
Yes. How much of that was good?
$4,000.
How much was SOB?
$1,000 SOB through the jail. Mr. Dunnigan, I understand that you have questions. The best thing to do is to speak to Ms. Wills regarding any questions. If you have a limited question about the bond, I can hear that. But what I don't want you to do is speak about the facts of the case that may result in further incrimination in violation of your constitutional rights. What is your question?
Well, I spoke to my mom yesterday, and I guess my mom had been in contact with Ms. Stearns about the whole thing. And from my understanding, she had left the home.
Okay. What I decided and what I ruled is that if she's not there, you can go back.
Yes, ma'am.
Okay.
What I was going to say is I know her living situation is hectic. So if she's still there, she's not able to leave. I have plenty of other residents that I can go to until everything is up.
All right. So that sounds like it falls in line with the ruling today. All right. All right. All right. Best of luck to you, sir. Does that complete the entire calendar?
Yes, ma'am.
All right. And after further consideration, Mr. Handspike will receive a $3,000 SOB to the jail with the same conditions. All right.
Thank you, ma'am.
Thank you, Judge.
All right. All right.
What happened with McGee?
Medical reset is what I have.
Yes, medical reset.
All right. I believe that concludes the entire calendar. Ms. Champion, with this review.